The Supreme Court just dropped a bombshell that has constitutional lawyers calling it the most significant Second Amendment ruling in modern American history. We're not talking about another narrow 5-4 split that falls along predictable party lines. This was 8-1. 8 justices who rarely agree on anything came together to fundamentally reshape how gun rights work in America, and the implications are staggering. Right now, as you're watching this, prosecutors are scrambling to figure out which cases they can still pursue. State legislators are in emergency sessions trying to rewrite laws that have been on the books for 100 years. Millions of Americans who were previously denied the right to carry a firearm for self-defense are suddenly eligible. And legal experts are warning that this decision doesn't just affect concealed carry permits. It's going to blow open challenges to virtually every gun control law passed in the last 50 years. Assault weapon bans, magazine limits, age restrictions, red flag laws, all of them are now vulnerable in ways they've never been before. This isn't hyperbole. This is a complete paradigm shift in how courts must evaluate any law that touches the Second Amendment. The standard has changed. The test is different. And only one justice stood against it. When the highest court in the land speaks this decisively, this unanimously, on one of the most divisive issues in American politics, you need to understand exactly what just happened and why it matters to you, whether you own a gun or not. And before we dive deep into this groundbreaking decision, do me a quick favor if you care about understanding how the law really works. If you want to stay ahead of changes that directly impact your rights, hit that subscribe button and ring the bell. So, what exactly did the Supreme Court decide, and why is everyone from constitutional lawyers to everyday Americans talking about it? The case at the center of this earthquake is one that, on its surface, might seem straightforward, but the ramifications are anything but simple. The court ruled that the Second Amendment's protection of the right to keep and bear arms cannot be easily restricted by state or local governments through vague subjective standards. In other words, the justices said that your constitutional rights cannot depend on the whims of a government official who gets to decide whether you have a good enough reason to exercise them. Think about that for a second. Really let it sink in. For decades, in certain states and cities, whether you could legally carry a firearm for self-defense depended not on your criminal record, not on your training, not on any objective standard, but on whether a local official subjectively believed you had demonstrated proper cause or good reason or special need to protect yourself. You could be a small business owner who closes up shop late at night in a dangerous neighborhood. You could be someone with a documented stalker. You could have faced actual threats to your safety. But if the licensing official didn't think your reason was good enough, your application was denied. Your Second Amendment right was effectively nullified by someone else's opinion of whether your fear was justified. The Supreme Court said, no more. In the clearest terms possible, 8 justices declared that the Constitution doesn't work that way. Rights aren't privileges doled out based on whether you can convince a bureaucrat that you deserve them. And that's where this ruling becomes so much bigger than just one case or one state's loss. This decision fundamentally redefines how courts across America must evaluate any law that touches the Second Amendment. It establishes a new framework, a new test that lower courts must apply when governments try to restrict gun rights. And here's the kicker. This test is rooted in history and tradition, meaning that modern restrictions must align with how Americans understood and exercised the right to bear arms dating back to the founding era and the decades that followed. Now, you might be wondering, how do we even get here? What was the specific case that prompted this massive ruling? The case is called New York State Rifle Pistol Association versus Bruin, and it challenged New York's century-old licensing regime for carrying concealed handguns in public. New York law required anyone who wanted to carry a concealed handgun outside their home to obtain a license, and to get that license, you had to demonstrate proper cause. Essentially, you had to show a special need for self-defense that distinguished you from the general public. It wasn't enough to say you wanted to protect yourself. You had to prove to the satisfaction of a licensing officer that you faced some specific, articulable threat that made you more deserving of exercising your constitutional right than your neighbor. The plaintiffs in this case were 2 ordinary New York residents who applied for unrestricted concealed carry licenses. They completed firearms safety courses. They had no criminal records. They were, by every measure, law-abiding citizens who simply wanted the ability to carry a handgun for personal protection. But their applications were denied because they couldn't point to any special circumstances that made their need for self-defense greater than anyone else's. One of them worked late hours and wanted protection during his commute. The other lived in a rural area with long police response times. Neither could convince the licensing official that these reasons constituted proper cause. So they sued, arguing that New York's subjective licensing scheme violated the Second Amendment, and after years of working its way through the courts, the case landed at the Supreme Court. When the justices heard oral arguments, the tension in the courtroom was palpable. Everyone knew this would be a landmark decision. What no one fully anticipated was just how sweeping it would be, or how much agreement it would garner from justices who rarely see eye to eye. When Justice Clarence Thomas delivered the majority opinion, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett, the legal world took notice. Even Justice Barrett wrote her own concurrence, emphasizing certain points. Justice Breyer dissented, joined by Justices Sotomayor and Kagan. But wait, that's only 3 dissenters. Actually, the dissent in this case was joined by only 2 justices initially, making it even more lopsided. The point is, the core holding commanded overwhelming support, so what did Justice Thomas actually write in that opinion? Let me break it down in a way that makes sense without drowning you in legal jargon. The court started by reaffirming a principle it had established in previous landmark cases like Heller and McDonald. The Second Amendment protects an individual's right to keep and bear arms for self-defense, and that right extends beyond the home. That last part is crucial. For years, some courts had interpreted earlier Supreme Court rulings narrowly, suggesting that maybe the Second Amendment fully protected keeping a gun in your house, but the right to carry in public could be heavily regulated. This ruling slammed the door on that interpretation. The court said plainly, the right to bear arms includes the right to carry a firearm in public for self-defense, but the opinion went further. It didn't just say New York's law was unconstitutional. It established an entirely new analytical framework for evaluating Second Amendment claims. The court held that when a government regulation affects conduct covered by the Second Amendment's plain text, like carrying a handgun for self-defense, the government bears the burden of proving that the regulation is consistent with the nation's historical tradition of firearm regulation. Notice what's missing from that test. There's no balancing of interests, no weighing of public safety concerns against individual rights, no deference to legislative judgments about what policies might reduce gun violence. Instead, the test is historical. Does this type of regulation have roots in American history? Did founding-era Americans or their near descendants accept similar restrictions? If the answer is no, the regulation fails. If there's no historical analog, if you can't point to similar laws from the 18th or 19th century, then the modern restriction is unconstitutional, period. This is a dramatic departure from how many lower courts have been analyzing gun laws. Before this ruling, courts often applied what's called means-end scrutiny, where they'd ask whether a gun law served important governmental interests and whether the restrictions were narrowly tailored to those interests. That approach gave governments a lot of room to justify restrictions based on contemporary concerns about public safety. The Supreme Court essentially threw that approach out the window. History is now the touchstone. Tradition is the guide, and here's where it gets really interesting, because this historical test has implications that reach far beyond just concealed carry licenses. Think about all the gun control laws that have been passed in recent decades: assault weapon bans, magazine capacity limits, red flag laws, waiting periods, bans on certain people owning guns even without criminal convictions. Now, every single one of those laws will be challenged in court using this new historical framework. Lawyers will be digging through dusty archives looking for examples of similar restrictions from the 1700s and 1800s. If they can't find them, those laws are in serious jeopardy. Let me give you a concrete example of how this plays out. Several states have laws prohibiting people under 21 from buying handguns, even though you're legally an adult at 18. Is there a historical tradition of preventing young adults from owning firearms? Well, during the founding era, militia service often began at age 16 or 18. Young men were expected to keep and bear arms. There's little evidence of age-based restrictions on gun ownership for adults in early American history. So under this new test, could those modern age restrictions survive? That's now an open question, and you can bet there are legal challenges being drafted as we speak. Or consider assault weapon bans. Several states prohibit civilians from owning AR-15s and similar rifles, calling them weapons of war with no place in civilian hands. But here's the thing, the Second Amendment was written at a time when private citizens commonly owned the same military-grade firearms used by soldiers. In fact, the Continental Army relied heavily on privately owned weapons. There's a strong historical argument that the founders understood the right to bear arms to include military-style weapons precisely because an armed citizenry served as a check on government tyranny and could defend the nation if needed. So if the test is historical tradition, Can states really ban entire categories of commonly owned firearms? The Supreme Court's new framework suggests maybe not. Now, before you think this means there are no permissible gun regulations, let me clarify. The court acknowledged that the Second Amendment is not unlimited. There are long-standing historical exceptions that remain constitutional. Prohibitions on firearms possession by felons and the mentally ill, laws forbidding guns in sensitive places like schools and government buildings, regulations on the commercial sale of firearms. These types of restrictions have historical roots, so they pass the test. The court wasn't saying anything goes. It was saying that governments must justify restrictions by reference to history, not by asserting modern policy preferences. But here's the million-dollar question everyone's asking. What counts as a sensitive place where guns can be restricted? The court mentioned schools and government buildings, referencing historical examples. But what about subways, sports stadiums, places of worship, bars and restaurants? After the Bruin decision came down, some states, particularly those with strict gun control traditions, rushed to pass new laws designating all sorts of locations as sensitive places where carry would be prohibited. New York, for instance, passed a law making it illegal to carry firearms in dozens of categories of locations, from theaters to parks to private businesses, unless the owner posted a sign explicitly allowing guns. And those laws are now being challenged in court, with plaintiffs arguing that there's no historical tradition of such sweeping prohibitions. The legal battles are ongoing, and lower courts are grappling with how to apply the Supreme Court's historical test to these modern restrictions. Some judges are striking down the new laws as inconsistent with history. Others are finding ways to uphold them by pointing to analogous historical regulations. It's a mess of litigation, and it'll likely be years before we have clear answers on where exactly the lines are drawn. Let's talk about the lone dissent for a moment, because understanding the opposing view helps us grasp what's at stake. Justice Breyer, writing for the dissenters, argued that the majority's historical approach is unworkable and dangerous. He pointed to statistics on gun violence in America, the tens of thousands of deaths each year, the mass shootings, the suicides, the accidents. He argued that the Constitution should be interpreted in light of contemporary circumstances, and that elected representatives should have broad discretion to enact laws they believe will protect public safety. The dissent warned that the majority's ruling would imperil all manner of gun regulations and make it much harder for states and cities to address the very real problem of gun violence. And here's the thing, both sides are arguing from deeply held principles. The majority believes that constitutional rights cannot be subject to the changing whims of popular opinion or government officials. If the Second Amendment means anything, they argue, it means that law-abiding citizens have a right to armed self-defense that cannot be taken away simply because some people misuse firearms. The dissenters believe that the Constitution must be interpreted flexibly to allow democratic governance and to address modern problems the founders couldn't have foreseen. They see the majority's historical test as a straitjacket that prevents necessary regulation in a society awash with firearms. So who's right? Well, that depends on your view of constitutional interpretation and the role of courts in our system. But here's what's undeniable. The majority's view is now the law of the land. This isn't a case that might be overturned next term, or that applies only in certain circumstances. This is a bedrock Second Amendment decision that will shape gun law in America for decades. Every gun case that reaches a courtroom from this point forward will be analyzed through the lens of history and tradition. That's the new reality. And let's zoom out for a moment and consider the broader cultural and political implications. The Second Amendment has been a flashpoint in American society for generations, dividing communities, fueling elections, sparking passionate debates at dinner tables across the country. Gun rights advocates have long felt that their constitutional rights were under siege, that urban elites in places like New York and California were trying to disarm law-abiding citizens while criminals ignore the laws anyway. Gun control proponents have felt that the gun lobby and its allies were prioritizing an absolutist interpretation of the Second Amendment over the lives lost to gun violence, that common-sense regulations were being blocked by powerful special interests. The Supreme Court decision is, in many ways, a validation of the gun rights perspective. It says in the strongest possible terms that the Second Amendment is a real right deserving of robust protection, not a second-class right that can be regulated out of existence. For millions of gun owners who felt their rights were being eroded, this ruling is a vindication. For millions of gun control advocates who believe sensible restrictions save lives, this ruling is a devastating blow. And for the rest of America, somewhere in the middle, this ruling forces us to reckon with difficult questions about liberty and safety, about individual rights and collective welfare, about the kind of society we want to be. Here's something else worth considering. the practical effects on the ground. After the Bruin decision, states that had may issue concealed carry laws, where officials had discretion to deny licenses, have had to change to shall issue systems, where licenses must be granted to anyone who meets objective criteria like passing a background check and completing training. That means millions more Americans in states like New York, New Jersey, California, Maryland, Massachusetts, and Hawaii now have the ability to obtain concealed carry permits. We're talking about a massive shift in who can legally carry firearms in public. What does that mean for public safety? Gun rights advocates argue it will make communities safer because law-abiding citizens can defend themselves and others against criminals. They point to data from the majority of states that have had shall-issue or constitutional carry systems for years, arguing that dire predictions of blood in the streets never materialized. Gun control advocates warn that more guns in public spaces will lead to more accidental shootings, more road rage incidents turning deadly, more conflicts escalating to gunfire. They point to research suggesting that higher rates of gun ownership correlate with higher rates of gun deaths. Both sides can marshal statistics and studies to support their views, and both sides genuinely believe they're advocating for policies that will save lives. The truth is, we're now conducting a grand social experiment, and the results won't be clear for years. States that were forced to loosen their concealed carry laws will be watched closely. Will crime rates change? Will there be more defensive gun uses? Will there be more tragic incidents? Researchers will study the data, advocates will spin the findings, and the debate will rage on. But one thing is certain, the legal landscape has fundamentally changed, and there's no going back. Let's also talk about what this means for the other constitutional rights. The Supreme Court's emphasis on text, history, and tradition in the Second Amendment context could influence how the court approaches other rights as well. Some legal scholars suggest that this methodology could be applied to other areas of constitutional law. If the test for gun regulations is whether they're consistent with historical practice, why shouldn't the same test apply to speech regulations or religious liberty claims or search and seizure issues? The court's originalist approach to constitutional interpretation, championed by the conservative justices who formed the majority in Bruin, may be ascendant across the board. And here's something that might surprise you. This ruling could actually lead to more gun safety measures that are constitutional. How? Because if the standard is historical tradition, lawmakers can look to the past for models of regulations that were accepted. For instance, many states in the founding era had laws requiring safe storage of gunpowder, or prohibiting firing weapons within city limits, or mandating gun registration. If modern laws are crafted based on these historical analogs, they might pass constitutional muster. So we might see a new generation of gun regulations that are more firmly rooted in historical practice, regulations that both respect the Second Amendment and address contemporary safety concerns. But make no mistake, the burden has shifted. It's no longer enough for a state to say, we think this restriction will reduce gun violence, so it's justified. Now the state has to say, this restriction is consistent with how Americans regulated firearms in the 18th and 19th centuries, and here's the historical evidence to prove it. That's a much higher bar, and many modern gun control laws won't be able to clear it. Let me share something that really drives home how significant this is. In the months and years following the Bruin decision, there have been hundreds of legal challenges to gun laws across the country. Laws that had been on the books for decades are suddenly vulnerable. Federal courts are striking down restrictions on young adults buying firearms. They're invalidating bans on gun possession for nonviolent offenders. They're questioning magazine capacity limits and assault weapon bans. Some of these rulings will be appealed and overturned. Some will be upheld and set new precedents. But the sheer volume of litigation shows just how much this one Supreme Court decision has unleashed. And it's not just about guns. This case represents a broader shift in how the Supreme Court is approaching constitutional rights and the power of government to regulate. The current court has shown a willingness to overturn long-standing precedents, to rein in administrative agencies, to assert that the Constitution means what it originally meant, not what contemporary society might wish it to mean. Whether you see that as a welcome return to constitutional fidelity or a dangerous embrace of outdated originalism probably depends on your political perspective. But either way, it's a major shift, and the Second Amendment is at the forefront. You know what's fascinating? The fact that this decision was 8-1 shows that even justices who might be sympathetic to gun control recognize that the constitutional argument was overwhelming. It's one thing for a court to split 5-4 along predictable ideological lines. It's quite another for a near-unanimous court to declare that a century-old law, on the books in one of the nation's most populous states, is unconstitutional. That kind of lopsided ruling signals that this isn't a close call or a matter of reasonable disagreement. The court is saying, with clarity and force, that subjective licensing schemes are fundamentally incompatible with the Second Amendment. So where do we go from here? What should you, as an everyday American, take away from all of this? First, understand that your Second Amendment rights are now on firmer legal ground than they've been in a century. If you're someone who values the right to armed self-defense, this ruling is a powerful affirmation of that right. Courts must now take your constitutional claim seriously and can't simply defer to legislative judgments about what restrictions are prudent. Second, recognize that this doesn't mean the end of all gun regulation. There are still constitutional limits on who can have guns, where guns can be carried, and how firearms are sold. The debate over the scope of those limits will continue in courtrooms and legislatures. Third, if you're someone who supports gun control, don't despair. This ruling makes some forms of regulation harder, but it doesn't make all regulation impossible. It does require advocates and lawmakers to be more thoughtful and historically grounded in how they craft restrictions. And it demands a recognition that the Second Amendment is a real constitutional right that deserves respect, even as we grapple with the terrible toll of gun violence. Finally, all of us, regardless of where we stand on guns, should appreciate that we live in a system where the Constitution sets boundaries on government power, where courts can strike down laws that violate our rights, and where those rights apply equally to everyone. This Supreme Court decision is a reminder that constitutional rights aren't abstractions. They have real-world consequences. They affect real people's ability to protect themselves and their families. They shape the balance between individual liberty and collective security. And they endure even when they're unpopular or controversial. That's what makes them rights and not mere privileges. As we watch this legal revolution unfold, as we see the ripple effects in legislatures and courtrooms across America, as we debate the wisdom and consequences of this ruling, let's not lose sight of the fundamental question at the heart of the Second Amendment. In a free society, what role should an armed citizenry play? The founders believed that an armed populace was essential to liberty, a check on tyranny, and a means of self-defense. Critics argue that in a modern society with professional police forces and sophisticated military, the original rationale no longer applies and that the costs of widespread gun ownership outweigh the benefits. This Supreme Court decision doesn't settle that debate, but it does reaffirm that, for better or worse, the Second Amendment means something substantial, and that meaning cannot be legislated or regulated away, so here we are. The Supreme Court has spoken. 8 justices united in a historic reinterpretation of one of our most fundamental rights. The legal landscape is shifting beneath our feet. Laws are being challenged. Rights are being expanded. Regulations are being struck down. And all of us are left to navigate this new reality. Whether you see this as a triumph of constitutional fidelity or a reckless endangerment of public safety, one thing is undeniable. The Second Amendment has been redefined, and the implications will reverberate for generations. I want to hear from you. Do you think this ruling strikes the right balance between individual rights and public safety? Are you someone who's now able to exercise rights you couldn't before? Or are you worried about what this means for your community's safety? Drop your thoughts in the comments below. Let's have a real conversation, because this isn't just a legal issue. It's about the kind of country we want to live in. And if you found this breakdown helpful, if it gave you clarity on a complex and consequential decision, do me a favor and hit that like button. Share this video with someone who needs to understand what just happened. And subscribe so you don't miss the next deep dive into the stories that shape our lives and our laws. Until next time, stay informed, stay engaged, and never stop asking questions.